If you are going to deny to individuals a benefit, you must explain it. You must have a reasonable justification. Why not use Afrikaans? Why only use English? It was a very simple question, but the government of Namibia offered no answer, said nothing. The government of Namibia simply said, English is our official language. Yes, so you're still denying to some individuals something of a benefit. You must offer a justification, a reasonable justification. They did not, and so the committee said, to only use English here is discrimination. That is another revolution, because it means that the government, even though English is the only official language, has to use or has to do something against or not discriminate, which really means in this case has to use Afrikaans within the government departments. This is rejected by a lot of lawyers. Once again, they're slow to learn these things because it goes against our paradigm, our way of understanding the relationship between language and official language policies and non-discrimination. But it has opened the door, and it suggests that in areas where you have a large percentage of the population that use a language other than the official language, where you have either a very large proportion or a very large number, governments should use the minority language to the degree that is reasonable and justified in the context. And finally, there was, once again, another very recent decision, 2002, in the case of Cyprus versus Turkey, where the European Court of Human Rights actually kind of admitted that you may have, in some situations, a right to be educated in your own language. Now, that may sound very simple, but in terms of international law and our understanding of the right to education until then, this is another revolution. It's something that we simply don't quite know how to handle. But there are hints, as I'll be indicating earlier on. So what we have here is a series of recent developments in international law that are based not on cultural rights, but on basic human rights law that have opened the door to a whole new understanding of the possibility of language being protected to some degree in some situations in human rights treaty law. What does it all mean in practical terms? The various declarations, conventions, and recommendations that I've all mentioned earlier, including from the Council of Europe, from UNESCO, the United Nations, and the OSCE, they all tend to reflect similar values. They're not written in the same way. But if you start dissecting or analyzing them, what you find really are values of what I would suggest are values of tolerance, accommodation, rather than assimilation and discrimination. And they tend to recognize that in a modern democratic state, we have to be based on respect. And that means respect of the individuals and respect on diversity. And we have to actually recognize the centrality of language and culture and the respect of fundamental human rights, which includes language and other aspects of culture. And all of this is covered, or is quite closely connected, to freedom of expression, freedom of religion, and non-discrimination. So what you have, if you look at the documents that have started to appear, really from the 1970s, and really has continued in Europe, but also internationally since then, what you have is a trend, a definite trend, towards agreement on the need to adopt constructive measures for the use of minority languages and respect for their cultures. And there's really a strong agreement on various elements or principles, approaches that we have under all of those documents. Among them, well, first is really the concept that fundamental to the approach of a democratic, tolerant society is that states must respect the diversity that is represented by ethnic, religious, and linguistic minorities. And this means not just, or more than just tolerance. It means perhaps also, where possible, promotion as far as reasonably possible, and especially in relation to language, which is central to all human societies. Because language diversity is really one of the most precious elements of our human cultural heritage. Sorry. Secondly, it's pluralism, and respect for individuals means that linguistic, religious, and cultural preferences must be acknowledged and accommodated rather than ignored or even suppressed. Thirdly, in relation to the private use of language, most of the documents that I've mentioned earlier, or those that really do deal with any kind of private activity, all agree that in relation to the private use of language, the basic principle is freedom. Public authorities cannot suppress or restrict one's private language preferences. And finally, the most controversial, the newest understanding, but the one which is also reflected in many documents, especially those that are not legally binding, is the acceptance that when dealing with the use of a minority language by the administration, by public authorities, including public education, the approach that should be adopted is proportionality in relation to a language used. I'll explain that a little bit further on. Sorry, I'm going too fast there. Proportionality. The use of language by government, by the administration of the state, by public, in public education. How do you put that in practice? Especially the European Charter for Regional or Minority Languages actually does suggest an approach here that's on proportionality by the government in the use of the minority language, where you have public authorities at the national, regional, or local level, where you have a sufficiently large number of individuals who use a particular language. The authorities must provide an appropriate level of service in this language. For example, in the case of local districts and their administrations where minorities are concentrated, local authorities should generally use at an increasing level of services their language as the number of speakers of a particular language increases. That's like a sliding scale level or approach. The more you have, a larger number of individuals you have who speak a minority language, especially if they are concentrated in a district, the more of the services of the government should be in their language. And in fact, in the case of a very large percentage of the population that use a minority language, or a very large number of them that are located in a region, then the minority language really should be a co-language of the offices of the government, or maybe even the main language of the administration in that region. If you have 10 million people, or 25 million people in some parts of India, who all share the same language, then really the language of government should mainly be their language in that region. This is a sliding scale approach, the proportionality approach to the use of language. Not all languages can be treated identically. It makes no sense to treat a language spoken by 1,000 people the same way as a language used by 10 million. Of course not. When we're talking about the use of a language by administration, by government, you must comply with a, broadly speaking, a proportionate, a sliding scale approach. That would be the approach in the documents from Europe, talk about languages generally, and I would suggest to you that's also the approach that would be consistent with the concept of non-discrimination in international law. Treating identically things that are different can be discriminatory. You cannot treat everything the same all the time if they're different.